All right, well, let's get started. Welcome, everyone. It's nice to see so many people joining for today's webinar, Speaking Up Under Trump, What to Know About Whistleblowing and Free Speech. We hope to have a very lively discussion today. Thank you for being here. We have over 235 registrants for this event, so obviously this is a very timely and important subject. My name is Tim Whitehouse. I'm the Executive Director of Public Employees for Environmental Responsibility. For those of you who don't know what PEER is or what we do, we are a nonprofit organization that represents government whistleblowers. We work on environmental, public lands, and public health issues at the federal, state, and local level. PEER attorneys specialize in whistleblower protections, First Amendment rights, and civil service laws. We represent our clients pro bono, meaning we don't charge them. Next slide, please. We have a very full agenda today. For today's webinar, Joanna Day, PEER's General Counsel, will spend a moment talking about the historic moment we are in and the dangers these times pose for federal employees, particularly whistleblowers, and the free speech rights for federal employees, and why the need for advocacy has never been greater. After Joanna, Paula Dinnerstein, PEER's Senior Counsel, will speak about whistleblower rights for federal employees. Joanna will be followed by Colleen Zimmerman, PEER's Staff Counsel. Colleen will talk about the rights of public employees to speak on issues of concern in their private capacity. Finally, Kyla Bennett, PEER's Director of Science Policy and a former whistleblower herself, will offer her perspectives, tips, and thoughts on the need for action and advocacy in these dangerous times. During this webinar, we'll leave the chat open. Please be sure to share your thoughts and ideas in the chat. If you have questions, please put them in the Q&A box. You can upvote during the Q&A process for those of you who are familiar with what that is. We'll be monitoring the Q&A box and we'll try to monitor the chat as much as possible. We know there are many experts on the call. We know there are former whistleblowers, and we know there are people with no experience on this issue. So we hope to engage all of you in a lively discussion. If there's time between the panelists, we will have, if there's time and we're not running behind, we will have time for Q&A between each of the panelists, and then we'll save about 15 to 20 minutes at the end for a moderated Q&A. Next slide. So let's jump right in and get started. Joanna?
Thanks, Tim. Hello, everyone. Thank you so much for joining us today. Just by way of brief introduction, my name is Joanna Citron-Day, and I recently joined PEER as the General Counsel after over 20 years in the federal government, working as an environmental enforcement attorney, most recently at the Department of Justice, and prior to that at both Department of the Interior and the Environmental Protection Agency. We live in unprecedented times. Our elected officials are supposed to serve the public. Instead, our federal government, led by Donald Trump, is being weaponized. There is widespread illegality, traditional checks and balances are not functioning, executive power is being consolidated. The result? Many bad things, including attacks on federal employees, growing. People are being forced out of the federal government in a variety of ways. They're pushing buyouts and early retirement to pave the way for loyalists, shutting down of offices, large-scale firings, for example, of probationary employees, reduction in force, attempts to strip people of protections and make them at-will employees, loyalty tests, and on and on. In addition to what's happening within agencies themselves, there is a lack of congressional oversight. Congress has been confirming heads of agencies who seek to cripple the essential functions of these agencies they lead, or even worse, dismantle them completely. Congress recently rubber-stamped the presidential budget that has catastrophic cuts to critical government agencies, including the Environmental Protection Agency, regulatory rollbacks and huge reductions, getting rid of the Office of Research and Development being one of the significant recent developments. The result will be dirtier air, water, and land. cuts to National Oceanic and Atmospheric Administration, NOAA, including slashing of staff and programs that hurt the ability to predict and communicate severe weather events and hurt our ability to respond to emergencies, as we saw recently with the Texas floods. Also, there have been very deep cuts to the Department of the Interior, exploiting public lands and resources in the name of energy production, and rollback of protections to endangered species, just to name some of the problems. There is a culture of fear in Congress. Presidential actions are to be followed and not questioned. Layering on top of those issues, both in the executive branch and Congress, there is the Supreme Court. Recent Supreme Court decisions have further accelerated this decline and the attacks on federal workers. The Supreme Court has allowed Trump to fire the heads of independent agencies, including the Merit Systems Protection Board, the Office of Special Counsel, and most recently, the Consumer Product Safety Commission. Supreme Court decisions have been paving the way for reorganization and reductions in force to continue at many agencies. And many of these cases are coming up in the emergency docket, the so-called shadow docket, where they are decided quickly and without much explanation, but have significant impacts, including continuing these horrific attacks on federal workers. There's a lot of litigation that's ongoing, and hopefully there will be victories later on, but this may take years. And it's difficult to predict how agency heads will respond to dissent among federal workers. There appears to be inconsistency between agencies, sometimes even within offices of one agency, and there's just an overall lack of predictability. Traditional disclosure routes, such as inspectors general, which were fired early on in the Trump administration, the Merit System Protection Board, the Office of Special Counsel, the National Labor Relations Board, are all being eroded by this administration. The goal of flooding the zone is to overwhelm and convince people that there's no point to speaking out. But there has never been a more important time for dissent. That's where PEER comes in. We work with public employees, both current and retired, to speak out smartly. What does that mean? PEER provides information to help public employees, current and former public employees, understand ways to speak out and to be informed about potential risks. We also help people explore how to shine a light on improper or illegal actions without personal exposure, or at least less personal exposure. How do we do that? We do public webinars like the one we're having right now, targeted webinars for more discrete groups of public employees. There's a variety of information on our website, and there is the ability to do individual consultations, current and former public employees, through an intake form that is also available directly from our website. Tim, back to you.
Thank you, Joanna. I had a question since we have some time.
Sure.
Your background is very interesting. You've worked in 3 federal agencies. Do you want to tell us a little bit about that and what the transition to PEER has been like, what you've seen in terms of our work in the 3 months you've been here? 3 months or 2 months?
2 months.
2 months. Time flies.
We packed 3 into 2. Sure, I'm happy to do that. While I was able to work on a variety of environmental laws throughout my time in federal government and enforcing these laws, Clean Air Act, Clean Water Act, Superfund, a variety of others, what's great about working at PEER is the ability to work directly with people, both through providing information, legal counsel, and you see that direct impact in a way that's different than what I did in the federal government and is extremely rewarding, particularly during these really complex times.
Right. Thank you, Joanna. We'll move on now to, unless I see any Q&As, I don't yet. Let's move on to Paula Dinnerstein. We can bring her slides up.
Yes, hello. My name is Paula Dinnerstein. I'm PEER's senior counsel. I've been with PEER since 2006 and have participated in a lot of our whistleblower work. So I have a fair amount of experience in different kinds of whistleblower issues, and now trying to adjust to the unprecedented times that we're in. And my presentation is going to be about the whistleblower rights of federal employees. So next slide, please. So the question is, what avenues do federal employees have to challenge disciplinary actions taken in retaliation for speaking out or reductions in force? And the main options that I'm going to discuss are the Office of Special Counsel, Merit Systems Protection Board, Equal Employment Opportunity Commission, and the courts. Kyla, in her presentation a little later, will discuss a few more avenues beyond those. For members of bargaining units, there are also union grievances. And these administrative avenues are required before you can go to court. So you can't go to court on a whistleblower matter unless you've been through one of these agencies. And although you can represent yourself in these proceedings, it's always best to have a lawyer, and not just any lawyer, but a lawyer specialized in the field of whistleblowing or whatever your claim is. Next slide, please. So what does it take to be covered as a whistleblower? There's several grounds on which a federal employee can challenge some action taken against them, whether it's firing or something else, including just that whatever the basis of that action, some claimed misconduct didn't really happen on the facts, that you didn't do it. What whistleblowing is actually a defense to an adverse action, claiming that even if the employee engaged in the charged conduct, discipline is not permitted under the law if it's based on retaliation for whistleblowing. So whistleblowing is a shield and not a sword. Excuse me. One of the misconceptions is that if you make a disclosure, you declare yourself a whistleblower, you are protected from all kinds of actions against you. Unfortunately, that's not the case. You can only raise whistleblowing after you've already been subject to some disciplinary action and you're raising it as a defense to that action. So what does it take to be a whistleblower under the federal whistleblower law? You must make a disclosure of one of three basic categories: either a violation of law or regulation, a danger to public health or safety, or gross mismanagement or abuse of authority. And the courts have interpreted all these words for many years in very complex and nuanced ways. And that is one of the reasons why you should really consult an attorney before blowing the whistle. The attorney can help you, whether it's peer or somebody else, can help you have a disclosure that will be covered so that you frame it correctly so that it does come under the law, or they can tell you this is not going to be covered. And then you know that, and you can make your decisions accordingly. Unfortunately, both the whistleblower fora, the MSPB and the OSC, have been largely neutered by Trump, who fired the special counsel and one of the MSPB board members. But as you'll see in the ensuing discussion, they still have some utility to go for them. Next slide, please. So first, the Office of Special Counsel. This is a special agency just devoted basically to whistleblowing and other what are called prohibited personnel practices, or PPPs, such as nepotism or discrimination. And you can either bring a complaint to the Office of Special Counsel that you've been retaliated against for whistleblowing or one of these other prohibited personnel practices. You can also bring what's called a disclosure, where you're not complaining about your personal situation or your job situation, but you're disclosing some kind of wrongdoing that comes under those categories of whistleblowing that I just went over. And the Office of Special Counsel will investigate your disclosure and go back to the agency if they agree that it's a legitimate disclosure. So Trump fired the special counsel There's an acting special counsel now who's not friendly to whistleblowers at all, but he has claimed, and we'll see how true this is, that he's going to let his staff continue their work without interruption. And so there's plenty of longtime staff at the Office of Special Counsel who are still very much motivated to do the job that that office is supposed to do. You file with a simple form, and it even applies to probationary employees can file there. Next slide, please. So then there's the Merit System Protection Board, which is the basic civil service court. There you can only, unlike OSC, make challenges to major personnel actions, firing, demotion, or unpaid suspensions of more than 2 weeks, and you can't be a probationary except for RIFs. Reductions in force can be challenged, including by probationers. You can start out with a simple online complaint, but then you go into a very demanding process where we're again recommending you have an attorney, leading to a trial type hearing before an administrative judge. After that trial type hearing, you can appeal to the 3-person Merit Systems Protection Board. And from there, if either side doesn't like the outcome, you can appeal to the U.S. Court of Appeals, a U.S. Court of Appeals. So even without a quorum, which is what happened now because of Trump firing the head of the board, and there's only one person on the board because somebody else had resigned earlier, they don't have a quorum. They can't decide appeals. However, if you file a case, you can still have a hearing before an administrative judge. You can get that far. And if you happen to lose before the administrative judge, the employee can go straight to court, whereas the agency cannot. But if you win your case as an employee and the agency appeals to the board, it can sit for a long time. Trump has now nominated somebody to be on the board, which would then bring back the quorum. And that nomination may be approved fairly soon, but there's already quite a backlog from the period where there was not a quorum, so it could sit for a long time. And even before Trump, both the OSC and MSPB options are weak. They're certainly far from ideal, and even the more so now. And we often combine these actions with publicity to pressure the agency to settle. Next slide, please. So the last one I'm going to talk about is the Equal Employment Opportunity Commission. They hear claims of racial, national origin, gender, disability, etc., discrimination. So if you fall under one of those, you can contact an EEO counselor at the employee's agency. You can choose EEO counseling or some form of alternative dispute resolution, such as mediation. If that doesn't have a satisfactory conclusion, you can file a discrimination complaint with the agency EEO office, and the agency will do an investigation and make a decision, or go on to the employee having a hearing before the EEOC judge. And then from there, you can go to federal court. And this is the only one of the avenues that we'll discuss where you can actually get a trial in federal court with a jury, unlike the other avenues of of MSPB and OSC, and the ones Kyla will talk about also. Next slide, please. There are union grievances. This is available to union members and employees in bargaining units. This usually involves arbitration, and the collective bargaining agreement for the particular union and agency will usually covers firings and reductions in force. The particular collective bargaining agreement will say what it covers, so you might want to check that if you are in a union. For whistleblowing and other prohibited personnel practices, you have to elect a remedy between the union grievance, the OSC, the MSPB, and the EEO. So you can choose one of those, but once you make that selection by filing in one of those places, that's what you're stuck with. You can't change that later. With the OSC and MSPB largely crippled, as we have described, a union grievance can become more attractive. Trump is trying to nullify these collective bargaining agreements, and that is in court now, so stay tuned as to whether that remains a good avenue. Next slide, please. Then there are disclosures to Congress. You can disclose, a federal employee can disclose to individual members of Congress or to committees. They can seek hearings, investigations, information, or other requests to the executive branch. And the Lloyd-La Follette Act states employees' right to petition Congress, which shall not be interfered with. However, if you are challenging an adverse employment action, you must go through OSC and MSPB, as I described before. You can't go straight to court under this statute. Next slide, please. Finally, even after somebody leaves federal employment, there are certain restrictions on what they can say and do in accordance with conflict of interest laws and government ethics regulations, particularly as to former employees. 18 USC 207, which is a criminal provision, says that a former employee cannot take part in a suit against the government or advocacy to the government concerning a matter that they worked on during their employment. And there are nuances to that as to what kind of things you can do for different periods. Some of them are for a lifetime. Some of them are only for 1 year or 2 years. So that's something that, again, you should consult a lawyer to get into the details. As it is a criminal law, it's subject to criminal penalties, so you want to be very careful about it. Although it is very rarely enforced, we never advise people to take a chance with a criminal violation. So if you're considering taking action, consult your agency ethics official. If you doubt their advice, consult an attorney. So that concludes my presentation for now. Thank you very much.
All right, Paula, I have a couple questions I think we have time for. Paul Ingracia has been nominated by President Trump to be head of the special counsel. He has called federal employees parasites and bugmen, among other things, which I couldn't repeat on this webinar. You mentioned there's still some utility. Obviously, he's not being confirmed. There is some bipartisan opposition to him. Can you delve a little bit more into your understanding of the OSC right now and how it functions and what utility it has to emphasize that route a little bit more?
Yeah, so if you file either a complaint or a disclosure, complaint being about your personnel situation, disclosure being about some government malfeasance that you've witnessed, but not necessarily asking for personal relief. The OSC has investigators, and this is the longtime staff that I mentioned, that's been there, many of them through different administrations, and many of them are really dedicated to doing their jobs and trying to help whistleblowers. And as I said, the whistleblower community had a meeting with the person who's basically acting as a special counsel now, and he insisted, that he's not going to interfere with their work, that they can go forward. So we don't know how true that is or at what level he might interfere, but it's certainly possible, and we have seen the OSC doing its job on that initial level, continuing to do so. Ingracia, is an extreme nominee even for the Trump administration. His hearing the other day was postponed because the committee, had more questions about him. So he may not be confirmed. The fear is that he's sort of put out there to make anybody else look good. So they could nominate somebody who's 80% as bad, and everybody will go, oh, phew, it's better. But it won't be good. But so we'll have to see as this develops what happens and how much the new special counsel is going to sort of lord over the staff who are doing the work.
Right. Thank you, Paula. And I think one thing to highlight there is even in Congress now, we start are starting to see pushback against certain nominees that are really extreme, like Paul Ingrassia, and we're starting to see some pushback against budget decisions. So advocacy at that level makes a huge difference, and we should never forget that. Thank you, Paula. We'll move on to Colleen Zimmerman. Colleen has a very interesting case and is working on some really interesting issues at Peer. Colleen?
Thanks, Tim. Hello, everyone. My name is Colleen Zimmerman, and I'm a staff counsel at Peer. I have been with Peer for over 3 years and work out of our headquarters in Silver Spring, Maryland, just north of Washington, D.C. Before joining Peer, I was an assistant district attorney with the Suffolk County District Attorney's Office on Long Island. I'm happy to be here today to discuss the First Amendment and your right to dissent. Next slide, please. The United States was founded on dissent. From the signing of the Declaration of Independence to the fight for civil rights and gender equality, it is arguably one of our country's core values. So much so, the right to dissent is enshrined in the First Amendment as freedom of speech. The Supreme Court has recognized that federal employees do not forfeit their rights to free speech, freedom of association, and the ability to petition the government when they join public service. In these times, it's more important than ever to make sure that federal employees understand their rights and what types of speech are protected. Next slide, please. In general, if you are a federal employee speaking as a private citizen about a matter of public concern and your speech does not interfere with a legitimate government interest, your speech is protected. While this sounds simple and straightforward, there are decades upon decades of case law that delve deep into what exactly this all means. First, what does private citizen mean? In short, you are acting as a private citizen when you are not acting in your capacity as a government employee. Typically, this means you are off the clock, not using government resources to communicate your message, and not referencing your employment with the government. It's also important to note that constitutional rights generally apply to non-citizens within the United States, regardless of immigration status. So although the term used here is private citizen, it is not exclusive to citizens of the United States. Next, what is a matter of public concern? The Supreme Court has ruled that speech deals with matters of public concern when it relates to any matter of political, social, or other concern to the community. It cannot be speech solely in the individual interest of the speaker. Deciding whether speech is of public or private concern requires the examination of the content, form, and context of that speech, or, simply put, what was said, where it was said, and how it was said. Finally, what constitutes speech that interferes with a legitimate government interest? According to the Supreme Court, legitimate government interests include the effective and efficient fulfillment of its responsibilities to the public, promoting efficiency and integrity in the discharge of official duties, and maintaining proper discipline in public service. In cases where the government seeks to curtail the speech of its employees, all of these factors are examined under a microscope. Ultimately, it comes down to balancing the interests of a public employee as a private citizen in commenting upon matters of public concern, and the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. These types of legal determinations are made on a case-by-case basis. Next slide, please. However, there are exceptions. Releasing classified information, such as national security information, is not protected speech, and you could face criminal prosecution. Confidential business information, or CBI for short, is sensitive, non-public information that a business or organization wants to keep private to protect its competitive edge or legal interests. It includes trade secrets, financial information, customer data, and other proprietary information that could cause harm if disclosed. Like classified information, if you release CBI, you could face criminal prosecution. The Hatch Act restricts the partisan political activities of certain public employees. It aims to protect the integrity of the federal workforce by preventing coercion and ensuring employees are free from political influence in their work. There may also be agency-specific rules that prohibit certain types of speech. It is always best to obtain legal advice to help you figure out whether or not particular types of speech are likely to be protected. Next slide, please. PEER is committed to protecting public employees who wish to exercise their freedom of speech. To illustrate how we are engaging in this work, I'd like to share a story about one of my clients. Carolyn McConnell is a field attorney for the National Labor Relations Board, or NLRB. She is also the vice president of the North Cascades Conservation Council, or N3C, a position she has held since before joining the federal workforce. In February 2024, she and an N3C colleague drafted an op-ed concerning the National Park Service's decision to remove rangers and close a visitor center in part of the North Cascades National Park. She submitted the op-ed to her NLRB ethics office for review and informed them the Seattle Times wanted to publish it shortly. Additionally, she mentioned that N3C was circulating a citizen's petition urging the Park Service to restore ranger coverage. The ethics office informed McConnell that she should not meet with national park officials in delivering the N3C petition, so she did not do so. They also told her that if she proceeded with the op-ed while the ethics office was assessing it, she could do so at her own risk. When she didn't hear further from the ethics office, she interpreted the advice as a caution and gave the go-ahead to the Seattle Times, which published the op-ed in March 2024. She wrote the op-ed and added her signature on the citizen's petition as a private citizen with no reference to her NLRB employment. Afterward, however, the ethics office filed a criminal referral against McConnell, asking the U.S. attorney to prosecute her for violation of a penal code provision on conflicts of interest. After the U.S. attorney declined prosecution, the ethics office then asked the NLRB Office of Inspector General, or IG, to investigate. The IG found that she engaged in misconduct by representing an organization before another federal agency. Then NLRB Regional issued her a letter of counseling. The NLRB claimed that she likely violated a federal criminal conflict of interest law, even though her advocacy was in her own name, was on a matter of public concern, and was completely unrelated to her work for the NLRB. Nevertheless, these government officials contended that her social activism would be grounds for future disciplinary action or possibly criminal prosecution. In March 2025, PEER filed a lawsuit against the NLRB to protect McConnell's free speech rights. While McConnell was targeted under the Biden administration, this lawsuit takes on added significance given the Trump administration's attacks on federal employees and its blatant attempts to intimidate federal workers from speaking out. A U.S. attorney appointed by this administration is unlikely to hold back when asked to prosecute. If McConnell could be targeted for criminal prosecution for simply asking for a park visitor center to be staffed, no federal employee is safe. To that point, this case has broad implications for all federal employees, and for that matter, for all Americans. If the attempted silencing of Carolyn McConnell is not challenged, it will give license to the current administration to pursue similar prosecutions of other federal employees. This is a dangerous precedent with the current administration's assault on the right of federal workers and the public good. Next slide, please. So here are a few key takeaways from my presentation. First, federal employees do not forfeit their rights to free speech, freedom of association, and the ability to petition the government. Second, those who exercise their rights are courageous, but it is not without risk, and everyone has a different risk tolerance. To that point, it is always best to obtain legal advice to help you figure out whether or not particular types of speech are likely to be legally protected. This concludes my presentation. Thank you so much.
Thank you, Colleen. I think you brought up some very disturbing points and issues that people in this country aren't aware of. And that is how the rights of public employees to speak freely has been curtailed. And it's not just a Trump issue. The Carolyn McConnell case started in the late Biden administration. And is still ongoing, although we filed the suit in the Trump administration. Could you just talk a little bit about, at a higher level, the statute and what we know about that?
Sure. So the statute that they claimed that McConnell allegedly violated was 18 U.S.C. Section 205. And in relevant part, it subjects federal employees to criminal penalties if they act as an agent or attorney for anyone before any department, agency, court, court-martial, officer, or civil, military, or naval commission in connection with any covered matter in which the United States is a party or has a direct and substantial interest. Now, I know that's a lot, but the real relevant part of that is covered matter. So the statute defines covered matter as any judicial or other proceeding, application, request for a ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest, or other particular matter. And again, the key term here is particular matter, which is not defined. So when they alleged that she had violated this statute, they claimed that her advocacy was a particular matter. So again, because Section 205 is a criminal statute, and because it has the potential to infringe upon the rights of employees under the First Amendment by restricting their freedom of speech, association, and right to petition the government, it should be interpreted in a manner to ensure that the statute gives fair notice of its coverage and that constitutional questions may be avoided.
Yeah, thank you, Colleen. And this should be of concern to anyone that in their private capacity that's a public employee advocates on behalf of an organization, which we all do in our private capacities, most of us on this call. Thank you, Colleen. We will move on to Dr. Kyla Bennett.
Thanks, Tim. Hi, everybody. My name is Kyla Bennett, and I am Pure's Director of Science Policy. I have a PhD in ecology and a law degree. I worked at EPA in Region 1, Boston, for almost 10 years, and I became a whistleblower while I was there. And that's how I met the wonderful people at Pure. I have now been with Pure for 24 years. I know that dates me, but I'm old. Today, I'm going to talk to you about 3 other avenues that federal employees can take as whistleblowers, give examples of each, and then discuss the pros and cons of each path. I'm then going to suggest an alternative to whistleblowing, which is anonymous activism, and that tends to be safer. The first other whistleblowing avenue is this. There are 6 environmental laws that have whistleblower provisions written into them. Those 6 statutes are the Clean Water Act, the Clean Air Act, the Safe Drinking Water Act, the Toxic Substances Control Act, the Solid Waste Disposal Act, and CERCLA, or Superfund. So when you file a complaint under one of these statutes, you have a very short statute of limitations, typically 30 days from the time that something happens to you. And the complaint is filed with the Department of Labor, which is very different than the other avenues that we've discussed so far. The nice thing about these provisions is that they can be broader than the Whistleblower Protection Act, and in some ways, in some specific ways. Specifically, the types of retaliation that are covered under these whistleblower provisions in the environmental laws include things like intimidation, making threats, blacklisting, or reassignment. There are downsides of this avenue, which I won't be getting into because it's wonky, but I did want to flag these as a possible avenue. And indeed, this is what I used when I was an EPA whistleblower. In my case, my boss at the time, who was a regional administrator, a political appointee under Bill Clinton, ordered me to withdraw my concerns on a wetland permit for political reasons. And he was very blunt about that. He said, the politicians, the Democrats don't want this permit to be denied, remove your objections. So I had found that the impacts associated with a port project on Sears Island, Maine, violated Clean Water Act regulations. I refused to back down, and the regional administrator threatened to take me off the case. I told him to try me, and he threw me off the case and he reassigned me. When he did, Pure filed a complaint with the Department of Labor on my behalf, and EPA capitulated immediately. And to this day, decades later, the permit for the port on Sears Island has not issued. I did stay at EPA for 5 years after I blew the whistle, but I was always labeled as a troublemaker. The second avenue is filing under the scientific integrity policy for your agency. This can be something like a differing scientific opinion or an actual complaint. One example of this is a scientific integrity complaint that Pure filed in January of 2020, which was signed by 44 EPA, Fish and Wildlife Service, and Corps of Engineers employees. Many former employees signed with their names and their former titles, and many current employees signed anonymously. And it was all about the new Waters of the United States rule. So what is a wetland? What is a water that's regulated under the Clean Water Act? The complaint alleged that the new rule under the Trump 1 was written without regard to any science, and that the science that they did use was completely mischaracterized. While the complaint got decent media coverage, nothing changed. Why? Because the scientific integrity process is broken. And not only is it broken, it doesn't have an enforcement mechanism. So why am I even mentioning this avenue? I'm hoping that someday things will change and these scientific integrity policies at federal agencies will become enforceable and will become a good avenue of redress for federal employees. The third avenue is filing a complaint with the Office of Inspector General. And as Paula mentioned, when Trump first came in this time around, he immediately fired 17 inspector generals, and it was shortly after his inauguration, and he has not yet replaced them with his own picks. So the acting inspector generals are running the show, and they are career people who do seem to care. I have been working with EPA's Inspector General for over 4 years now. We have a number of EPA chemist clients who have alleged malfeasance in the approval of new chemicals, and we submitted numerous detailed complaints to the IG. And while I do have faith in the IG, their investigations have been comprehensive, they've been compassionate, they've been patient, they're incredibly slow. The IG did finally, in September of 2024, rule that 3 of our EPA clients were illegally retaliated against, and they did get some redress from this retaliation. But the substantive reports on who did the retaliation and the reports on the underlying malfeasance still have not come out, and here we are 4.5 years later, which is incredibly frustrating not only for Pure, but for our clients. The other downside to this avenue is that the Inspector General does not have enforcement capabilities themselves, although they can refer matters for enforcement. So you should understand by now, after hearing all of us talk, that there can be downsides to being a whistleblower for 2 primary reasons. Many of the avenues of relief are blocked or really difficult at this point in time, and particularly under this administration, retaliation and becoming a pariah are real possibilities. It is never easy to be a whistleblower, but it's not always the best way to remedy the underlying issue. A better option in some cases is engaging in what we call anonymous activism, which is simply a way of focusing on the message itself and not the messenger. In other words, expose the problems, what is happening behind closed doors at your agency, without exposing yourself. There are numerous benefits to anonymous activism as opposed to whistleblowing. First, it can prevent you from experiencing retaliation because no one knows it's you. Second, it allows you to continue to keep the agency on the right path. In other words, you can fight from within. And third, you can affect real change. In addition, we often see a beleaguered agency turning to the anonymous activist for help when the issue is outed. And that can be incredibly satisfying. I mean, after all, if you're an expert in a particular matter and you've outed it somehow safely and they don't know it's you, they may turn to you to help fix the problem. So how do you engage in anonymous activism? It involves working with a trusted partner to expose issues and malfeasance to the harsh light of day. Public opinion and embarrassment can sway these agencies to do the right thing. But even anonymous activism needs to be done carefully. 3 things to keep in mind. First of all, you need to make sure that you're not the only one or one of just a few people that has this information. We often recommend to people that they should paper the record and spread it widely. In other words, if you see a document that's really concerning to you and you think it might lead to malfeasance or some big problem, don't try to out that to the media. You need to write an email to 50 people, 100 people, say, wow, I'm concerned about this. Anyone else concerned about this? Make sure that it's spread widely so you cannot be pointed at when the issue does see the light of day. Use FOIA, the Freedom of Information Act. We can often FOIA for a huge number of documents. If there's one memo out there that you want to get out, And if you release it, everyone's going to know it was you because you're one of few people that have it. We can FOIA for a huge universe of documents in order to get that needle. So we will FOIA for the haystack in order to get the needle. And that way the agency doesn't know that's what we were looking for. Third, and very importantly, please make sure that your media and your NGO partners will protect you. Many of you may have heard or read about the Stand Up for Science letter, where 139 EPA employees were put on leave for signing this letter of dissent. This was a problem. You need to make sure that whoever you're working with knows how to protect you and knows whistleblower laws. So I want to leave you with two closing thoughts. First, we are all in the same storm, but some of us are in yachts and others are swimming without a life preserver. Don't take on more than you can handle. We need you in these agencies to fight back. But also, please try not to judge others for inaction. Being a whistleblower takes courage, and you have to be able to withstand the inevitable reaction from the agency. Think about other ways, like anonymous activism, that can remedy the situation. And finally, and perhaps most importantly, don't give up hope. Sometimes just getting information into the public view can cause agencies to reverse course. And we've seen this under the Trump administration. And also, as my first boss at EPA told me the very first day I started working there, he said, "We may not win, but we can damn sure ruin their day." So Pure is here to help you find ways to win and also to ruin their day if that becomes necessary. Thanks.
Great. Why don't we go to Q&A now? So if the presenters want to turn on their cameras, we have about 14 minutes left. One of the questions right up front was Pure works with environmental whistleblowers. Are there other organizations that work with other types of whistleblowing? And the answer is yes. And just before we close out this presentation, we'll put a slide up with some of the other organizations we work with. So my first question is to anyone on the panel, but I think Paula or Kyla or both would be best able to answer it. What percentage of whistleblowing cases are successful? And I will caveat that by saying many of our whistleblowing cases, we end up with a non-disclosure agreement. So we can't talk about them even if we've had success. Kyla, Paula?
Yeah, so if you look at the statistics for the MSPB, they look terrible, like, 4% win their cases. And what the MSPB people will tell you, and I think there's a lot of truth to, is that quote unquote, the good cases settle. So while there aren't that many, absolute wins, we've had some for sure. If you have a good case and you're putting the pressure on, as I mentioned, through other means, you can often come away with a good settlement for your client.
Great.
I think it also depends on how you define success. And different whistleblowers I've found have different goals. Some of them want personal relief, a new job, money for the awful things that they've experienced, but others simply want the underlying environmental issue to be remedied. So a lot of those cases do go well. So I think it really depends on, it's hard to put a figure to how many successes, what percent are successes. A lot of them are, and some aren't.
Okay. Another question out there, and I don't know that we have a full answer to this question, but it's one we get a lot. Are there any protections for people that don't work for the federal government but are paid with federal funds? I know a lot of the contracts and grants are being canceled illegally, and I know there's different lawsuits going on about that. We do work with contractors as whistleblowers, and I don't know, Paula, if you or Kyla, if you have anything to add there.
Yeah, so there is a federal contractor whistleblower law, and the whistleblower community is working to strengthen it now in Congress. But there is a law, and we have represented contractors as whistleblowers in the past.
Okay,
Also, the whistleblower provisions in some of the environmental statutes also cover contractors, like the one for the Clean Water Act does. So I think that's a case by case, but some of them do.
right. Emily in the Q&A asks, there's a master plan to reduce staffing and increase workload until failure occurs, and then they can fire you for the inevitable, determining that you are incompetent and that was your fault. What avenues are open to you then? Do any of the panelists have reactions to, I think, what is an accurate description of what's happening in the federal government?
I'll chime in first, but I assume Paula and probably Kyla and probably Colleen may also have thoughts. I think that what this question goes to is the inevitable setup that I think that people already have been experiencing and anticipate is going to continue as, essentially what we've all talked about, the federal government is largely failing to protect federal employees. We are really working with people. This kind of goes back to the individual help we can provide for current and former employees and contractors in some cases, as Paula was just mentioning. We do individual consultations. You can fill out an intake form, and figuring out your particular situation for current or former federal employees, you can come to us, we'll talk through it. And I think, to the extent that the reason for firing someone or disciplining them is just a ruse and it's somebody's being targeted, we try to figure out how to work with someone to get them some relief in that situation. And I'll toss it over to other panelists.
And so that sounds like there are two categories that action can be taken. One is conduct and the other is performance. And this sounds like it would be a performance issue, saying that you have failed in your performance. You were, of course, set up to fail. But for the agency to take a performance action, they have to meet certain standards, and it can be challenged as they have to show that there's certain things like in your performance plan that you didn't do, that you didn't meet. And so, we have a fair amount of experience in litigating those kind of cases.
Right.
I just want to also add that I've heard from a lot of employees in agencies that are undergoing RIFs, the reductions in force, or reassignments, that they're afraid of being put in a job that they're not qualified to do for this very reason. So they're set up to fail so they can be fired. And so at some point, it might become constructive firing. I mean, taking somebody who has, a PhD in chemistry and putting them administering grants, obviously something that obvious is something that I think we could do something with, but it really depends. It's a case-by-case situation that we have to look at.
And just one other thing to add, and again, for people that are represented by unions, which there a lot of folks do have some kind of union representation. AFG, NTU are two of the big ones that we have worked with and will continue to work with. Again, you're welcome to consult with us, but certainly consult with your union representative as well to see if you may be able to file an individual union grievance is another avenue. So just.
And Colleen, you were an assistant district attorney in Suffolk County, and you've come to Pierre. And since you've been here, the atmosphere has changed quite a bit. You started in one administration, you're in a new administration. Is there a way you would characterize sort of what you're seeing on a higher level in terms of the type of work we're doing, and I think the type of work many other groups are doing?
Sure. So I feel like when I first joined in 2022, we were receiving a lot of whistleblower cases, genuine whistleblower cases of folks who wanted to speak out about a problem that they were witnessing within their agency. Now I feel like we've shifted focus to folks who are being laid off or fired as probationers. It's mostly, protecting federal workers as opposed to focusing on environmental issues that they're bringing to our attention. We're trying to protect the people who are trying to protect the environment and public health.
Right. Yeah, and that's important to realize. We like many organizations are dealing with a massive lawless attitude in the federal government and trying our best, working with other groups to stop that while maintaining a strong whistleblower docket. So the vibes definitely changed. The zone is flooded, and there is a lot going on. Let's see. Someone asked about EEOC cases. I will just say we at Peer don't take EEOC cases. If we get something that looks like an EEOC case, we're just not specialized in that. We try and find an attorney to work with them. And the question is how the war on diversity, equity, inclusion has affected that. I would imagine tremendously, but it's not an issue we work on. Someone else asked about listing things in the chat. I think we've been a little chat light today, but we will definitely send around links, important links to things we've talked about in a follow-up email. Someone asked about presentations to Democratic and independent members of Congress or their senior staff. I think we've done many presentations to different groups, and I think it's important for groups like Peer to build up their Hill presence and to really be advocates on the Hill to help people understand what an unchecked executive really means for government work and government services.
I just have something to add on that, Tim, briefly. So I know that a lot of Congress people, particularly right now, the Democrats tend to have what they call whistleblower, sort of hotlines or intakes that you can do. I think we would advise, and we have advised people to talk to us before engaging, only because those offices, while often well-intentioned, are not thinking about the individual's potential risk. And if there's one theme that you've heard from all of us today, is that we are looking out for the people. As Colleen was just saying, that's kind of where things have shifted and the nature of our work. So we would say to folks, I know that I was just speaking to someone yesterday, in fact, about this issue, and they had already reached out to a congressional office. It's really helpful to consult an attorney, and an attorney at Peer might be able to help you in that scenario. So I just want to add that.
Great. There are a couple final questions. We're coming up on an hour. An anonymous attendee asked, how do we stop the damage that's happening, especially pollution? Because we are focusing on the civil service, and in normal times, we focused on whistleblowers and pollution. And I think that's a really tough question. I don't know if anyone has any insights, but hopefully ultimately it needs to be public pressure combined with lawsuits and engagement. I don't know if anyone has anything to add to that.
Yeah, also working at the state level, Tim, because the federal government is hopeless for the next 3.5 years. So we really do need to work at the state level. And even some of the red states are stepping up and trying to fill the void that EPA has left in some of these, with some of these pollution incidents. So like Oklahoma, Texas even. So if you can work with your state DEPs or DECs or whatever they're called, and even locally, that's all we got right now.
Well, and I guess I would add that going back to what my original opening point of dissent is more important than ever, it's not falling on deaf ears in the federal government. It's just that the federal government is not functioning. And the more that Congress people, both Democrats and Republicans, hear from their constituents again and again and again, sign petitions, call, email, be a pain in the neck, be vocal. I think that's one thing that we encourage people to do, as far as if there's a particular issue or, sort of something that you see that you feel like a petition you want to sign. We often have things on our website, letters to Congress, etc. Don't hesitate from being loud, even though I don't disagree with Kyla that at the federal government level, it's not likely to make a lot of progress right now. But we all still need to, be raising these concerns again and again and again.
Another avenue that comes to mind is citizen suit petitions. So a lot of environmental laws have these citizen suit petitions baked in. So if you're a citizen and you're seeing a violation of an environmental law, you can sue the government to comply with that law. So you'd obviously have to speak to an attorney about that, but that is another avenue for relief.
Thank you. We are
So-
at 1 minute to 5. Paula, I'll give you the last word. We'll put up some
Oh,
closing
I was
slides.
just gonna say that, the question was kind of how can we stop the increased pollution and harm to the environment? And there are a lot of groups who are working on that. A lot of the things that the administration is doing are illegal and they're being challenged in court. Peer does some of that, but at present, we're pretty overwhelmed with the civil service issues. We will continue to do some of that, but we're also working with a lot of other groups who are challenging the illegal actions of this administration.
Great. So citizen engagement, both in the law and petitions with your congressman, are really important in these critical times, as is dissent. So for resources, we talked about contacting peer. This is our legal intake form. We also have a small legal resource center. We work with many other groups. There's a book here that we did with GAP, Government Accountability Project, and POGO, Project on Government Oversight, about being caught between your conscience and your career. And I listed 3 groups that we work with. I'm really proud of how the communities come together in these unprecedented times and working with law firms and Congress on both sides of the aisle to address some of these issues. We work closely with the Government Accountability Project, Climate Science Legal Defense Fund, and Civil Service Strong are just a few. I'm sure I've missed many. Next slide, please. So this is Peer. We always accept donations. We're active on social media. And if you have any follow-up questions, please let us know. We will send around a follow-up email to everyone that's registered with more information on this webinar. And we do post it on our YouTube station. So we'll send that link also. Any last comments for any of the panelists? Otherwise, we will sign off. Thank you, everyone, for joining us. Again, if we didn't get your Q&A, please reach out to us individually. We'll be happy to answer your questions. Thank you. Bye.